All right, ladies and gentlemen, those who are joining in, put a one in the chat if you can hear the sound of my voice. Put a one in the chat. We need to check out the audio as well as the video. Please put a one in the chat. Good morning, good afternoon, actually, ladies and gentlemen. So I'm here live outside the federal courthouse in the trial of Sean Diddy Combs. And what we're going to do first and foremost, I want to make sure my sound is good and my video is good and it's not choppy, because it's a struggle to bring good video outside in the rain because it's raining. So I want to make sure everyone is here. I want to make sure you guys are sharing this, because what I'm bringing to you today is exclusive details as it relates to the Sean Puffy Combs trial. What is happening in the courtroom? What is happening? What has happened? What started the ball rolling in this trial coverage? And we want to talk first and foremost about what the media has asked of the court. So I want to make sure everyone can hear me. I am going to be toggling back and forth from my car to the courtroom because of the rain. No cameras, none of my cameras is going to be in the rain today, because I don't think there's going to be any necessity to shoot anyone in particular, because I shot most of the people that are going to be participating this week, with the exception of Cassie Ventura, who is on the stand again this morning. So hopefully she can go through her entire testimony, both on direct and cross-examination. But we want to talk about, before we go into Cassie's complete, unedited version of her testimony, you guys heard clips yesterday of her testimony, but we want to go into the specific testimony versus the overview, because bringing everything to context requires that we look at every word, mannerism, and how she said it, her reaction to what she said. With that said, ladies and gentlemen, I am going to, I have my notes. I have a copy of the full transcript from yesterday, as well as I will have a full copy of the transcripts today. And while I won't read there's a lot of stuff. First and foremost, I got to caution everyone that's listening. There are things that have come out in this trial that pretty shocking. So when I say shocking, a little disturbing. And once again, I've interviewed Cassie. I've interviewed her in the past, and I'm gonna be honest with you. And I'm being very fair with both parties. Cassie is a very sweet individual. From when I talked to her, I never got the impression that she was someone that would intentionally harm another. I didn't get that impression. And I've seen Cassie multiple occasions. And to that point, I've met Puff on many occasions, and he has also been respectful to me and respected what I do for a living. With that said, let's just talk about what is at stake here. Mr. Combs is facing life in prison if the government can convince a jury that the allegations that are in an indictment are in fact committed. A very high burden for them to prove that. We heard a lot of testimony yesterday as it relates to what Cassie has portrayed as her being the victim of someone who had full control over her actions. What we're going to do today, during my lunch break, this is my lunch break, what we're going to do today is to listen to the testimony, and the people should have an opportunity to form an opinion based on the facts that have coming out in the facts of the testimony, not facts of the actual acts, but facts of the testimony that is being presented to the jury of men and women in the court today. With that, ladies and gentlemen, welcome to the show. I appreciate you guys making sure you are promoting the channel. Make sure you are. I need to probably put a banner on this. We are on StreamYard, so I do have the ability to do that. I have a power supply in the car for some of my devices. Hopefully we can get through this without my laptop dying. But stand by. Let me put a banner up. I want you guys to support the platform. Many won't have the time to do the details of this case. One, they don't have documents. Two, they don't have the ability to do it. Hold on, stand by. Put the banner up. Stand by. Here we go. With that, let's go. Here we go, guys. Let's see here. Here we go. All right, here we go. Okay, so let's get into some things here. Let me bring up the document that I need to look at here. I won't be reading the comments, so mods, make sure you're on your P's and Q's because I won't be reading the comments. I'll be looking at my document. We're just warming up, guys. We're just warming up. We have a few windows open. We're going to close a bunch of these windows just so it won't interfere with our live. Okay, guys. I drank coffee. I had a sip of this Red Bull, and I tell you, it gave me the jitters. So I probably won't be drinking Red Bull today. And it's not really good for you, but in any event, that's what I'm drinking right now. Hold on here, guys. Let's bring this up. Let's bring it up. Yeah, what you hear in the background is New York City traffic. A lot of noise. All right, here. Hold on. Here we go. There we go. We're about to start here. Grab this here. Okay, so let's go. Let me first one tell you guys who was present in the courtroom for the state. We'll get to that in a second. So representing the United States government is U.S. Attorney Meredith Foster, Maureen R. Comey, Emily A. Johnson, who is examining Cassie right now, Madison R. Smizer, Mitzi Steiner, Mary C. Slavic, and they're representing the United States government. And for the defense, present today is none other than Attorney Mark Agnifilo, Attorney Tini R. Garagos, Tremonte, Anna M. Esteva, Shapiro. Okay, we're reading the law firm. So we got Alexander Shapiro's here. We have Xavier Donaldson. We have Brian Steele, and we have Nicole Westmoreland, who I talked to yesterday briefly. She was trying to catch a cab, and cab wasn't stopping. So, welcome to New York, Nicole. Welcome to New York. So now, what we want to talk about is the issue that two of the jurors had getting on this panel, and we're going to start out with the court. This is verbatim. The court, two juror issues. One is from juror 160, and if you recall, I believe this is the juror who indicated that her son was graduating from high school, I believe, in June. I take it that she wants to make sure that she can attend her son's graduation, which I think is on June 20th. We can figure that out. We could keep people late other days. We'll make up the time. So what we know is this judge is going to be accommodating. We learned this just based on some of his prior rulings. So throughout this trial, which is expected to last 8 weeks, there are going to be people who have situations. And depending upon how the judge feels about the situation, he's going to make a ruling either to, we can't help you, or we'll try to accommodate you. Interesting that the graduation is being accommodated. And I think probably because, you can't redo a graduation. Parents have one opportunity to go to that graduation. And I think most people, average citizens, is going to opt for a graduation of their child rather than being a part of the jury. I included as well. I'm sorry, son or daughter. I'm going to have to sit in a Diddy trial and I can't go to your graduation. Who would want to make that something the child has to think about? Not even a child, a young adult has to think about. Their parent was spending time spending time as a juror in a Diddy case rather than being at their very special day where that tassel's tossed to the right and that cap is thrown up in the air and that gown is now you're walking across that stage. It's a beautiful moment. I've done it a couple of times. It's a beautiful, beautiful time. I've done it. My kids have done it. So yeah, I respect the judge for that. Here we go. We could keep people late other days. Okay. We'll make up the time. She's going to write a letter to me, which I'll share with you so you can understand what the issues are. And we can't understand what issue is, but we haven't received that yet. So they're waiting for the letter from this juror. So the juror better make sure the son is actually going to walk the graduation. Okay, guys, this morning we received a letter from juror number 75. I'll share this with you and we'll make this court exhibit 1. He says, I live in Westchester County with my wife, who is 75 plus. She is, and he's also older guy. She is also a cancer survivor. We have been married for 40 years. My wife's caretaking needs are very specific and precise, therefore are present. So now the judge has to decide, is the wife's care by her care provider is more important than him being here sitting on the jury. It's a very hard call to make. And I would want to be by my loved one. I don't know these people over here. I want to be by my loved one. And she's suffering from cancer. She's 75 years old. We don't know how long she's going to be on this earth. And we want to make sure that people are not inconvenienced to a point where it'll be, something that they had to, deal with for a long time. So I am only one who could take care of her in addition to cooking and cleaning the house on a daily basis. I hope you will take into account my unique situation in which I am responsible for the welfare of my wife, who will be greatly appreciated if my request for an excuse from the jury duty can be granted. So this is the letter. Share this with the parties. Now I will go get juror number 75 so he can come in and explain his situation. But based on this, I would not be. See here come on, judge. Come on, judge. You got it. Come on. Let's see here. We got to scroll up a little bit, guys. I would not be inclined to excuse this juror. And I don't think that he's asking necessarily to be excused. I think he doesn't know the situation and whether it's kind of an optional. Well, jury duty is not really optional. But he's been around for a long time. And is it not fair to assume that he may have been called for jury duty? I don't know. And so he's okay, excuse me, guys. And so he's suggesting that if it is possible to not have him serve on the jury, then he would take that route. However, I don't think this provides grounds to excuse this juror at this time. So these are the things that you must consider when going to be asked to commit 8 weeks of your life to a trial of people that you don't even know. So these type of things come up. We have one. He's gonna likely allow the juror 160 to attend her son's graduation, but this juror 75 is going to have an issue. What do you guys think about that? Do you think this judge should allow the man who's the caretaker of his wife to be excused in this instance, or do you think that he has to just sit on the jury. What do you guys think? What do you guys think? Because it's kind of a hard call to make, but judges make these type of calls all the time. What do you, excuse him. So we have one that says excuse him. We have, okay. And if he doesn't, if the judge doesn't excuse him, will he take that out on Mr. Combs? How do you think that will play out? I mean, whenever you have issues like this, you got to also consider not just the juror's situation, but also whether or not this juror will make someone pay for this. He could make the government pay for this because Sean Combs doesn't have the power at this point in the game to say, we don't want this juror. He doesn't have the power because the juror's already seated. The juror should, this is a rare situation. And I don't know. We have to assume the judge is going to make the right call, but it doesn't seem like he's going to excuse his juror. And if the jurors are alternate, they're about to lose an alternate. They're about to lose an alternate juror. But no, he's not even the alternate. He's a juror that's been seated. So I don't know if you guys think that this judge is being a little extreme, but we'll have to see. We'll definitely have to see. Guys, let me check the notes. Let me check and see if I get any alerts coming out the court. Stand by. Please give me a second. We're literally multitasking here. Nothing yet, so let's continue, guys. So the judge brings the juror out, and the judge tells the juror that he has to stay on the juror. He has to stay as a juror. The court, if something serious happens, then you can let me know. Right now, what I'm understanding from your letter is that you're letting me know what your responsibilities are and for whom. Juror, yes. The court. Now, unfortunately, once we have the jury, let's scroll this down. Once we have the jury, you're committed to being a part of this jury. Okay, Ms. Slavic, do you have, Ms. Slavic? No, nothing from the government. Mr. Agnifio, not from us. The court will continue. I'll let you know if we hear anything from 160 and we can head out and address the issues you have identified for today. And this was said in open court. The court, Mr. Agnifio, should we wait for Mr. Combs, or are you prepared to address the evidentiary and other issues without his presence? Mr. Agnifio, if he's up, I'd rather bring him out if possible. The court, okay, we have a letter from a juror that we address with the parties that will be made exhibit number 1. Next, on the issue of access to these sealed exhibits, the videos, when the sealed exhibits and the videos, when do we anticipate these being offered into evidence? Ms. Johnson, Your Honor, anticipation potentially offering images from those videos as early as this afternoon. I do think the government would oppose the application that was filed last night. If the court would prefer for the government to try to rework into the direct examination so that we can reach those issues tomorrow, to allow that the government an opportunity to put in a submission this evening, I can do that as well. The court, why don't we do that? I have to say that, reduce the document. Ms. Johnson, Your Honor, we anticipate potentially offering images from those videos as early as this afternoon. I do think this government would oppose the application that was filed last night if the court would prefer for the government to try to rework its direct examination so that we can reach those issues tomorrow to allow the government an opportunity to put in a submission this evening. I can do that as well. The court, we don't need to do that. I have to say that. What's the next page here? The next page here. I have to say that I've included. Now I have to say I'm inclined to grant the application that was made for the reasons that I previously addressed, which is we've made certain adjustments for certain of the witnesses, but in the very limited way, as the government indicated, this issue is different. This is about evidence that's coming into the case and treating that evidence in a different way than the other evidence here because of an understanding and a palpable and real issue of privacy and the personal interests of a witness. However, that has to be balanced against the usual First Amendment protection and the rights of the public to know about what is happening at the trial. So the media attorneys coming in to argue for the media, because whenever there's evidence that the government wants to have under seal or out of the eyes of the public, it is the media's responsibility to find out whether that evidence violates the First Amendment of the Constitution, where the public has the right to know. For example, there may be something on the video that may be shocking, but may be necessary to have a full understanding of what is alleged and what the real story is. Excluding certain things from the media leaves a shadow of doubt or questions that may be raised. And if we can't answer those questions, for example, someone said, Mr. Byron, what was and I saw this in a live I did. Mr. Byron, what was that exhibit that you spoke about in your tweet? Was it shown in the court? Well, no. Why not? What do they got to hide? People who have to trust the process and know that nothing is being intentionally hidden for nefarious reasons. This particular evidence in question is apparently some videos that person doesn't want the public to see. And it's going to be some graphic videos played. And then we saw some graphic stuff already. So let's continue. While we've handled a lot of the things under seal before trial has started, we are now in trial, and there's a heightened First Amendment concern in this context. I am not seeing how we could navigate that concern in this instance. So the judge is saying that we are already here. There now is a First Amendment issue being raised. This could have been raised early on. It still would have had to be addressed by the attorneys representing the media, but now we're here at that front door, and now we have to deal with it. I'm also a little bit concerned, and maybe the parties are not, that there is a potential impact on the jury when certain evidence, especially given the context and the nature of the evidence, is signaled to them to be of such a nature that the courtroom has to be cleared, and they're only people that can see it, and what message that sends to the jury. The judge is Exactly right. If I'm a juror and I'm sitting in a room and all the public is in the room, and then all of a sudden they come to a piece of evidence, and now the judge is telling everyone out the courtroom except the jury, the jurors, that gives me the impression as a member of the jury that this must be some bad stuff. And if the public can't see it, it's it's damaging to the defendant. Or maybe this guy's really guilty, and he's so guilty that they had to take the people out the room. That creates a major problem for the defense. And that's, not even for the media, but for the defense, because it leaves a bad taste in the juror's mouth. What it, like, is this that bad that we can't see it? We're all adults. We're grown. Now, some things I've heard, I've never did that in my entire life in this case. But again, we're adults. We've watched all kind of movies. We watch comedy, we watch horror, we watch all different, all different type of movies. So the minute you have to do something extraordinary in the courtroom, it does raise concern for the jurors, members of the press, the defense. So the judge is right by, and just think about how the judge is making these type of analysis. He's doing analysis based on not just a part, but the entirety of the case. We learned in the YSL case that it was a free-for-all. There was a lot of stuff that was coming in that shouldn't have came in. Judge didn't exercise extreme care in dealing with evidence and allowing things to come in. You had to shield different members of law enforcement. They couldn't testify on camera. It was different things that was happening in that case, that this judge is much more careful and respecting the rights of the First Amendment, the defendant, and the public. Here we go. So those are my concerns, which I'm happy to give you a chance to address in your response. Ms. Johnson, thank you. Your Honor, if I may I respond briefly to those, and we'll respond more formally later. The court, of course. Ms. Johnson, I want to be clear at the outset that the government nor the defense, I believe, anticipates clearing this courtroom. What would happen is that the materials that are a very small subset of the materials that are entirely sexually explicit or involves nudity or victims and others would not be shown to the public gallery. It would not require any logistics of people leaving the courtroom. Just think about that right there, ladies and gentlemen. Again, we're grown. If it is okay to show it to the jurors in a public trial, then it should not be censored in storytelling and telling the story. The public still have the right to see this. The ones who have come to the courtroom to see a public trial, they need to be apprised of everything that is a part of the public trial. Otherwise, you're now telling us that we have to spoon feed you certain evidence in this case. That, ladies and gentlemen, I have an issue with. But again, I am a non-party to this case. But if you think that any evidence that is being shielded from the public would prove to be a violation of the First Amendment, then we got to fight for this. And that's just my belief in this case. Okay, so here we go. Ms. Johnson, here. What would happen is, okay, we know that what would happen. Hold on. What would happen is that the materials that are a very small subset of the materials that are entirely sexually explicit or involve nudity of victims and others would not be shown to the public gallery. It would not require any logistics of people in leaving the courtroom. To the extent any of those exhibits have any sound that is also sexually explicit, we have arranged for headphones to be available for everyone in the well of the courtroom. Interesting. of the courtroom so that the sound could be played without impacting people's needing to leave the courtroom. So they did this in R. Kelly case as well. They did this in the R. Kelly case in New York. They put headphones on so the public couldn't hear it in the media room, so we didn't know what was being played. And let's see how the judge decides on this. So there would be sort of a no shuffling, and out to the extent that the logistics of the factoring into the court's consideration. But just on the nature of what these materials are, they are all sexually explicit or involve nudity, and that the parties, and I believe the attorneys for the victims, one has already submitted a letter. I believe that another victim will also want to be heard on this issue. We think we're on good standing in the Second Circuit to keep this type of material out of the public record, and we'll certainly put in a submission on that. Okay. My concern is still the same. Would this impact the storytelling of the case? We're grown. We should be able to hear any and everything. If you're a witness and or victim to participate in a public trial, you know it's a public trial. Some things is going to come in there. Am I being insensitive, or am I making a good argument? Only time will tell. Let's see what else happens here. Ms. Johnson continued. So I just wanted to flag those two items for the court. The court, Mr. Anifio, Mr. Anifio, yes, Judge. I think the timing makes sense. My read of the cases, my close reading of the application for unsealing, really the focus is on how good we are at narrowly tailoring the materials. I agree. And so it's just a few observations as we think about this through the day. And I think it makes sense if the government can get to this tomorrow. We can all have a little more time to figure out how we are tailoring this. So the defense agrees that some of the stuff shouldn't be shown either. I would guess if Mr. Combs is participating in it, they would not want that to be in the public space. Stand by, guys. I'm getting a call. Stand by. Stand by. Let's see this. Yes, hello. Yeah, I can't talk now. I'm covering the case. I'm sorry. I have to call you back. Please wait for my call. Thank you. Thank you very much. Bye. Okay, guys. Let me go ahead and get a little feedback from you guys real quick. So, what are your thoughts on that, guys? Before I continue, let me read the comments. Let's see here. Hold on a second here. Do you guys agree that some things should not be played to the public? Because they're going to be Cassie recorded a lot of this stuff on her phone. They're going to be acts that she engaged in with an escorts, but she recorded on her phone. And I was talking to an attorney yesterday, and she made a good point. Why is Cassie recording this stuff on her phone over the years? What was the point of her recording this? Why was she recording all this? Like, if this is something that you don't enjoy doing, why are you recording it? Can anyone explain to me the logic in that? If you don't enjoy the stuff that's being quote unquote happening to you, Why are you recording? But that's the argument that the defense is going to have to raise. If this stuff, was so bad to you, who would want to retain this on their phone? And that's what I'm wrestling with right now. If most people take pictures, do video, so they can reflect on that moment in time. And if it's that bad, it's awful. And what we heard does some of the testimony didn't align with what the acts, what happened afterwards. They're not aligning right now. They're not aligning. I'm gonna be honest with you. That I have an issue with that. So let's just let that sink in for a second. And I'm not victim shaming, but why you keeping this stuff? Like someone said, for evidence. After how many escorts? Like, oh no, baby. Hold on, guys. Hold on. I'm just asking for a friend. Like help me understand that. There's no point in retaining something that you just thinks is awful. But let's go. Let's see what else we got here. Okay, hold on. Okay, so parties to do this in a tasteful way, obviously. So we are not looking to affect testimony. We are not looking to do anything other than really address it's a privacy issue. But it's also, I think, it's not significant that this is all in the nature of pornography. It really is. And so my question is, what would the press do with this, even if they had it? What would the press do with that, even if they had it? That's a good question, Yana. I couldn't do anything with it. I cannot do anything with it. I won't show it. No one's putting it. Content creators not putting that video on their channel. Well, they won't have an opportunity to have the video. But are they going to write descriptive stories about what's in the video? Will the pages then be flagged for promoting pornography? Most media outlets will likely not run that. There's no value for their audience to know the details of those acts. We've heard testimony yesterday that was very detailed. We reported on, like I heard one interesting person say some very detailed stuff about what Cassie said, and we're gonna read it. We're gonna read it in a few minutes. We're gonna get into that. Make sure I have enough battery here for you guys. Yeah, I have about 10 more minutes, and we're gonna get into some things. So we're gonna rush through this real quick. I'm gonna read this kind of quickly. Stand by. I gotta give me some lunch. Hold on. Okay, so here we go. The court, Mr. Agnifio, the judge. Yes, sir. My read of the case is my close reading of the application for unsealing. Really, the focus is on how good we are narrowly tailoring the materials. I agree, and so it's just a few observations as we think about this through the day, and I think it makes sense if the government can get to this tomorrow. We can all have a little more time to figure out those things that we are tailoring for this. There is no aspect to any of the videos that I think the government is looking to put into a evidence that is not in the nature of adult pornography. That's really what it is, adult pornography. It's people who are nude, who are having sex or about to have sex. It's all sexually explicit. So it's not the case that anything would be looked to be sealed that's not sexually explicit. It makes a good argument. So we couldn't really tailor it any more narrowly than that. It is sex at the end of the day. It's pornography. It's something that has been taken from the bedroom and put on video and being recorded. Our application, to the extent that we have one and want to see how this all shakes out, is only that the visual images and the audio is within the purview of the sealing order. The parties would be free to tactfully, of course, ask questions about the evidence. So we wouldn't be looking to do anything in regards to testimony. The onus would be on the parties to do this in a tasteful way. Obviously, we are not looking to affect testimony. We are not looking to do anything other than the really address the issue. It's a privacy issue. Did I read that already? Okay, so no, I didn't actually. They just repeat themselves. There's no aspect to any of the videos that I think the government is looking to put into evidence that is not in the nature of the adult pornography. That's really what it is. Okay, we did read that. So why is that coming back up? I'm paging down. Okay, here we go. The court. How many exhibits are we talking about, and what's the running time of those exhibits? Miss Johnson, with respect to the next witness, there will be no video that will be at least on direct examination. It would be in the nature of 6 still images. And Your Honor, I can flag those for the court if Your Honor would like. We've provided chambers with the exhibits. So if you would like to review them, I can direct you to the exhibit numbers. The court, do you have the numbers now? Ms. Johnson, I can. The court, you can't have them emailed to chambers. That's fine. Briefly, does anyone on behalf of the news organization wish to be heard on this issue, given what Mr. Agnifilo has said and what Ms. Johnson has offered? Please approach. Yes, Your Honor. Dennis Byron, represent Hip Hop Inquirer. Your Honor, can you approach Your Honor? Here we go. It's not me, actually, someone else. I'm sorry. Deputy, good morning, sir. State your name. Mr. Bellin, Robert Bellin, Balin, of the Davis Wright Tremaine for the news organizations. The court, you heard Mr. Agnifilo. He says that the approach that the parties were intending on taking is a narrow one. The testimony would be in the open court. The only thing that would be under seal would be the visual images and the videos and associated audio that is purely reflecting sexual conduct. So, under those circumstances, is there still an objection, or under those circumstances, is it narrowly tailored enough to satisfy the First Amendment interest at stake? Mr. Bellin, I think that the prohibiting any public or press viewing of these videos would not be narrowly tailored. Your Honor is correct. The First Amendment is at a zenith in this type of case. In a criminal case, there are serious charges. The question is how we accommodate what are unquestionable privacy interests. I would say that the testimony is not a substitute for the videos. If it were, the government would not be putting it in stills, would not be putting in videos. They would obviously think they have some persuasive value. It is important that the press, the people through the press, be able to see justice being done. Makes a great point. Why put stills in when you can put the whole video in, because people now could see who was the I guess top bottom aggressive party, who was saying what in the videos with who was saying who was doing the directing. She testifies, Cassie, that Mr. Combs was directing. Would the video show something otherwise? So, and why shield it from the people that are watching the public trial? So it's a good argument. One of the issues in this case, Your Honor, of course, is were these acts consensual or coerced? Very good point. If the court is not inclined to show the videos in open court, and that is our preference, Your Honor, there are other ways, and the court does have to consider constitutionally other ways besides a total sealing to accommodate First Amendment access rights. Another option, of course, would be pool reporters. We could talk about the number of them, but at least some representatives of the press who can see the videos in real time. And I agree with that. I have no problem with that. It should be available to some members of the press who are trusted members of the press who will put a good narrative that supports what was being shown to them. So I totally agree with that. Time as they're being shown to the jury and be able to report. And the New York Times and the Washington Post and the Wall Street Journal are not interested in reporting anything salacious. We ain't talking about them. We're talking about Hip Hop Inquirer. We're talking about the other content creators that may be interested in reporting some of the stuff. They want to be able to, however, report that this was shown to the jury and here in a very discreet and appropriate and mature way is what they show. That's no different than any other trial, Your Honor. So we do strongly object to the total sealing of the exhibits. We think they should be shown to the press and the public. And in the, I don't know. Anyway, and in the courtroom, I'd add, Your Honor, we're not asking for copies of these exhibits. Typically, that would be part of the press access. We are not asking for copies. We do not understand the serious privacy concerns. We ask the court to try to craft something that not only has the privacy concerns considered, but the very strong First Amendment access right considered as well. That's our submission, Your Honor. The court. Ms. Johnson, as you're crafting your response, you'll take account of that proposal from the news organizations. Ms. Johnson, yes, of course, Your Honor. And I just wanted to make sure when I answered the court's questions, I talk about just the next witness. There are videos the government intends to introduce later. The next witness is Cassie. We're going to hold it there for a second, ladies and gentlemen. 1 second. So, do you guys agree with the position the media is taking on this case? Do you guys agree with the position the media is taking on this case? And if so, or if not, why don't you agree with the position that we are taking as it relates to public right to have access and the media's right to be able to encode the information coming from the videos? What do you guys think? Not all you at one time. Go ahead and put your comment in it. Do you agree that the public should have access to know the context, whether or not Cassie was being coerced, or was she doing the coercion? Because that is a very important thing to distinguish, because we hear coercion in the indictment and we read it in the indictment. Does the indictment support the claims made by Ms. Ventura? That's important. We need to make sure that if you're going to convict this man, it's going to be based on more than just quote unquote privileged individuals having access, but the people that can communicate that to the public. I'm always concerned when censorship comes in a criminal trial. I'm always concerned about that. And I'll tell you why. I've seen that some certain judges have used that approach to hide evidence. Not just judges, but prosecutors. They have used that approach to hide evidence, and then people have been wrongly convicted because of evidence being shielded from the public. And it's only when someone does a deep investigation and talk to witnesses, then we learn that, hey, well, this actually, there were things that was in the report that never made it to the public. Had the public known this back then, and the jurors knew this back then, they could have came to a different conclusion. So we got to be very careful when we want to shield certain things. But to that point, we also have to be concerned that no one is going to take a video that they've seen that was done in a criminal act to be now re-victimized a true victim. So we don't want to do that either. So we just have to say, hey, she was throwing the commands to him, or he was throwing the commands to her. He was doing certain things. But again, this case is not about pornography. It's not about pornography. We're being shown pornography. Is it necessary? Does the pornography support the charges? Remember, she was with him for 10 years. Does the pornography support the charges? I think shielding from the jury and shielding from the public are different. They are different because the jury has one certain role and the public has a different role, and the public has the right to be informed. The jury has the right to be informed, but they have an additional right because they are the now trier of fact. They have to try this man based on the facts. So they can't just assume something is what's the word I want to use? Too gruesome that it not need to be handled with kid gloves. They got to see everything. Whatever the government saw, the jury had to see it. And whatever the jury's seeing, the public needs to make sure that the jury's getting the right information. So that's my thoughts on it. We're looking for the RICO. We haven't, what we see is a lot of FRICO. We need to see the RICO. We need to see that. We need to see that. Ladies and gentlemen, I have to get back to the court. There's a part 2 coming on the next break. I'll see you guys on the next break. And the next break, we'll talk about Cassie's testimony, and that should happen in the next hour. So make sure you're locked in. Make sure you subscribe, and we'll be back. We'll be talking about Cassie's testimony very soon. Appreciate you guys. Thank you for coming in, and I'll see you guys on the next live.